I now recognize myself for an opening statement. I welcome my colleagues to this important hearing and welcome our audience and our witnesses today. I thank each of our witnesses for being here today, with special recognition for one of our witnesses who flew all the way from the UK to testify today. Thank you. Given advances in technology and the heightened interconnectivity of the digital era, personal data, business information, and sensitive communications are sent, received, and stored all over the world. Often, during an investigation, law enforcement needs to acquire this information from U.S. companies. Until 2018, if this information was held in another country, for example, a data server in Ireland, it wasn't clear whether U.S. law enforcement would be able to obtain it, even though it was requesting the data from a U.S. company. In 2018, Congress passed the Clarifying Lawful Overseas Use of Data Act, or the CLOUD Act, to address this gap in the law. Under the CLOUD Act, U.S. law enforcement pursuant to a lawful court order can obtain data held by U.S.-based service providers but stored outside of the United States. The CLOUD Act also provides avenues for our allies to enter into bilateral agreements with the United States to similarly obtain their citizens' data from these same service providers to assist with their own law enforcement investigations. Unfortunately, one of our closest allies, the United Kingdom, is taking advantage of its authorities under the CLOUD Act and is attacking America's data security and privacy. In February of this year, the Washington Post reported that the UK had secretly ordered Apple to build a backdoor into its devices to enable UK law enforcement to access a user's data stored on the cloud, including encrypted data. The CLOUD Act requires that a country entering into a data access agreement with the United States have laws that include robust protections for privacy and civil liberties. The UK's order, however, threatens the privacy and security rights not only of those living in the UK, but of Apple users all over the world, including Americans. This order sets a dangerous precedent and, if not stopped now, could lead to future orders by other countries. The UK's Investigatory Powers Act permits it to issue orders to tech companies, compelling them to weaken encryption or halt security updates for users around the world. This broad extraterritorial order highlights the tension between national security and individual rights. These interests are not mutually exclusive, and it is possible to protect both national security and individual rights. Providing law enforcement with the tools to conduct investigations is a laudable, important goal, but the UK, seemingly emboldened by its agreement with the United States under the CLOUD Act, has issued an order that will affect people all over the world, and this is a step too far. Encryption is a critical tool to maintain the privacy and security of digital information and communications. Efforts to weaken or even break encryption makes us all less secure. The U.S.-UK relationship must be built on trust. If the UK is attempting to undermine this foundation of U.S. cybersecurity, it is breaching that trust. If companies are forced to build backdoors to encryption, that simultaneously opens a backdoor to privacy rights, or an invasion of privacy rights, and is impossible to limit a backdoor to just the good guys. Just last year, Chinese hackers known as Salt Typhoon penetrated lawfully mandated backdoors, gaining access to wiretap systems used by U.S. law enforcement. The hackers also were able to access the private data of President Trump and Vice President Vance. This attack is a clear example of the dangers of surveillance backdoors. This should concern everyone. I've long had concerns about the CLOUD Act and the bilateral agreements it enables that could allow foreign governments to spy on Americans. Given the recent actions by the UK, I am concerned that the CLOUD Act is failing to adequately protect the privacy and security of Americans. In the wake of the UK's order, I've called on this administration to act decisively to protect Americans' communications. I continue to urge our government, including the Justice Department, to evaluate whether the CLOUD Act and our agreement with the United Kingdom are working as intended. If they are not, we should renegotiate the agreement to ensure that our rights are protected, and we should do so by invoking the 30-day termination clause. After years of senior U.S. government officials pushing for weaker encryption and surveillance backdoors, it seems the tide has shifted. Indeed, after the Salt Typhoon hack, our government publicly recommended the use of end-to-end encrypted communications tools. Director of National Intelligence Tulsi Gabbard stated at her confirmation hearing that backdoors lead down a dangerous path that can undermine Americans' Fourth Amendment rights and civil liberties. This hearing provides an opportunity to build on the momentum toward greater respect for privacy and evaluate whether and what changes are needed to ensure Americans' rights are protected. I am looking forward to hearing from our witnesses today, and again, thank you for being here and discussing how we can best move forward